People are saying that kicking the president off of Twitter violates his First Amendment rights. But does it? We'll answer that question on this edition of Pros and Con Law. Hello, and welcome to this edition of Pros and Con Law, the video channel and podcast that takes a look at constitutional and other legal issues of the day. We'll be taking a look at what the First Amendment has to say about Twitter kicking the president off of its services, if anything. But before we do that, I want to thank you all for subscribing to this channel or to this podcast. I want to please ask you to give any questions you have to our email address at prosandconlaw@gmail.com, or leave questions in the comments right below, or you can check us out on Twitter at Pros and Con Law. So let's take a look at what, if anything, the First Amendment has to say about this situation with Twitter and the president. To begin with, we have to start with the text of the First Amendment, which says specifically that Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people to assemble, peaceably to assemble, and to petition the government for redress of grievances. And while what's particularly important about the First Amendment in this case are the provisions regarding speech and the press, what's particularly important that we have to take a look at is that first couple lines. Congress shall make no laws regarding all of those topics. Now, there are many exceptions to all those topics, which we don't need to get into for our purposes here. But in this case, you have to remember that the First Amendment is a restriction on Congress, on the federal government's ability to make laws. Congress cannot make laws abridging freedom of speech or of the press. The Constitution says they can't do that. And we should also point out that the Supreme Court has ruled that the 14th Amendment allows the Bill of Rights, including the First Amendment, to be enforced against the states, so that states cannot make laws abridging the same freedoms that are protected against Congress. What this all means specifically is that the First Amendment's rights of speech and to the press apply to governments. This is what we call the state action doctrine. One of the questions you have to answer when you look at a constitutional law question is, what is the state action at issue? Is it Congress? Is it the state legislature? Is it a local county or city which operates by virtue of a grant of authority from the state? If it's not one of those entities, if it's not the federal government or the state government or city or county governments acting on something, we're not in constitutional law. If it's between two private individuals, it may be a question of contract law, it may be a question of tort law, but it's not a question of constitutional law. Specifically, in this case, Twitter is, of course, a private company, and it can decide to sell or not sell its wares, in this case, or services, to whoever it wants to. Now, it does have terms of service, and those may or may not be enforceable depending on where you live and what you signed, but that's a contract question. It's not a constitutional law question. And this is something that people get wrong either accidentally or on purpose at various times. For example, Senator Josh Hawley recently was dropped from his contract at Simon & Schuster and took to Twitter, in which he said that his First Amendment rights were violated. Now, Senator Hawley used to attend Yale Law School and also clerked for Chief Justice Roberts, but any attorney who has looked at the Constitution and constitutional law knows in their hearts that this is not a First Amendment issue. It's a contractual issue. He may have rights under his contract with Simon & Schuster. He may be able to sue them for damages, but it's not a constitutional issue. Now, we're putting aside the wisdom of dropping the president from Twitter. We're putting aside the wisdom of dropping Senator Hawley from his Simon & Schuster contract. Those are questions for a contract attorney and for the attorneys advising either Twitter or Simon & Schuster. But when you get right down to it, there is no state action. Now, you can certainly argue, as some attorneys have, that the First Amendment should be expanded to incorporate protections on this ground, that you can make a good faith argument that the law should change. And that may be wise or not. There are arguments on both sides. But the law as it is does not apply to this situation. Under the state action doctrine, there are certain circumstances in which private entities may be bound by the Constitution, but that's when they are fulfilling government functions, as in when you're running a private prison or handling actual U.S. mail for them as a independent contractor. You're bound by the Constitution when you are providing governmental services. Twitter is not providing a classical government service. People make the argument of it being a public forum, but it's not. It is a private forum. You have to sign up, and they have to approve you ultimately to partake in that, and you have to abide by the terms of service. Now, maybe the law should be changed, maybe it shouldn't, but as the law stands now, it just doesn't apply to Twitter. So if you see people saying that this is a First Amendment issue, I'm sorry to say that they don't know what they're talking about when it comes to constitutional law, or if they do, they're misrepresenting what the constitutional law actually says and what the case law actually says. And that's it. The First Amendment does not apply to any situation involving Donald Trump and Twitter. Where the First Amendment has been found to apply is that because the president, as a member of the government, is representing the government, he cannot block people because that is a governmental entity, the president, infringing upon their constitutional rights. That's it. That has nothing to do with Twitter per se. Twitter's not involved in that lawsuit. That is simply between the person who was blocked and the president. So there you have it. That's the answer to the question. What does the First Amendment say about whether or not Twitter can drop Donald Trump or anyone from its services? Nothing. Absolutely nothing. If you have any questions, please leave questions in the comments below. Like this video, please subscribe. You can email us at prosandconlaw@gmail.com or follow us on Twitter at prosandconlaw. Thank you so much for your patience, and thank you for tuning in to Pros and Con Law.